Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hi, and welcome back to the podcast channel for De Groots lawyers for wills and estates planning. And today we're joined by Emma Nisbet to help us out with another topic. How are you, Emma?
Good, thanks, Tony, and thanks for inviting me to be here.
Great. Look, thanks for taking the time. And today we're having a look at the art of bequest planning. And there's different types of bequests out there, but there are two main types: pecuniary legacies and residuary gift. So what is the difference between the two?
Well, pecuniary legacies are essentially where a person wants to give a specific gift of money in their will. So that might be if they want to leave a sum of money to a friend, a grandchild, or a family member. That's commonly termed to be a pecuniary legacy. In terms of the residuary gift, effectively, that's the gift of the estate once any pecuniary legacies or specific gifts have been made. So effectively, it's what's left over at the end after everything else has been given away that a person wants to provide in their will.
Do you always need to make an allowance for something like that?
Well, not really. It depends on what the will maker is actually wanting to do. So in some cases, a will maker might not want to make any allowance for pecuniary legacies or specific gifts. So probably just to explain further, as I mentioned, pecuniary legacies is a gift of money. A specific gift is a gift of something else, a specific item that might be named in the will. So it might be a gift of artwork, a gift of a property, a gift of jewelry. It can be whatever. It's just termed to be a specific gift because that object or the object of the gift or the gift itself is actually specified in the will. And we have a situation, I'm thinking more of a typical a family situation where you might have a couple in a relationship and they effectively want their whole estate to pass to each other, and they don't want to provide any allowance to leave a gift to anyone else in that first instance. Then it may just be that they're drafting their will in such a way that provides a gift of residue to that person. So there doesn't necessarily need to be an allowance for specific gifts or pecuniary legacies. It's really dependent on what the intention of the will maker is.
Okay, so I guess that would apply a lot more to bigger families.
In terms of making specific gifts?
Yeah, and setting things aside, like, for example, it's becoming popular leaving money to charities and so on and so forth. So can that be done via percentage via this methodology?
Yeah, there's many ways to distribute your estate. So there's actually no fixed rule of thumb. So you could leave a pecuniary legacy or a specific gift, but more commonly a pecuniary legacy. So that's a gift of funds to a charity. Alternatively, it ideally depends on what the will maker is wanting to do. So if they're wanting to benefit a charity, they may do that by giving us a fixed amount, essentially. Or it may be that they're giving a percentage of their overall estate to a charity or to a particular person. So it's really dependent on what their intention is and what they're wanting to do with their estate, who or what they may be wanting to benefit as well. So there's just a multitude of ways to craft your estate planning. There's certainly no one-size-fits-all approach in estate planning at all.
Okay. Now, something I just thought about, and we're not giving tax advice, but are there any tax implications potentially to be aware of?
Well, I mean, there's always tax implications to be aware of in estate planning. As estate planning lawyers, that's not something we generally advise on, aside to say that it's important that it is considered as part of the overall estate plan. Where tax implications mainly come into play It's dependent on the asset that you're dealing with. It's dependent on the beneficiary that's receiving it. That could be, for example, commonly in the case of a charity, the tax implications can be whether or not that charity is registered and has that deductible gift recipient status. So whether they're actually registered as a charity with the relevant Australian Charities Register, the ACNC. So there's many things that come into play. And in terms of individuals, it can depend on the asset they're receiving, whether or not that asset has capital gains tax implications, whether they're a resident, whether they're a non-resident, what their taxation status is. So it's very important that taxation matters are considered as a part of the overall estate plan, because that really might determine what you want to do and who you might want to leave assets to and what type of assets. So commonly, if you might have a child that's a non-resident and you're wanting them to benefit, you might just give some consideration as to what asset they're receiving. Are they going to receive an asset which isn't impregnated with taxation implications such as, shares? Are you going to leave them cash instead? So there's so many different things to think about as part of the estate planning. It's a very, I suppose there's many different facets, if I can just say that, Tony.
Great. Okay. And I just thought of something that popped into my head. What about cryptocurrencies? Because it all depends on values and so forth, and they can jump around a lot. Is that something you should be looking at individually as well?
Well, cryptocurrencies are, again, that's a really complex area of law in terms of estate planning. I mean, it comes within a digital asset. Your digital assets, basically. With cryptocurrencies, I suppose there's many complexities attached to that as well. The reason being is that with a lot of cryptocurrencies, they actually may be based overseas. So where that comes into play too is in the actual administration of the estate as to whether or not that particular entity who might be managing, so where the servers are located, etc., actually recognise the authority of a person to deal with that cryptocurrency, so who's authorised in the will. So when you are doing an estate plan, it's really important to consider whether or not a person does have cryptocurrency or other digital assets and how they might be best dealt with. Because the other thing is that often these assets are very specialised, and they have there might be certain keychains and passwords effectively that are needed to access those currencies. So that needs to be taken into account in terms of that estate plan, like how that might be accessed if the person who usually has that day-to-day access and holds those keys passes away as well. So that's a whole other topic in itself, and a really quite a complex one at that.
Yeah, exactly. And it just shows why you need experts like yourself to help you with estate planning to cover so many of these bases and this modern NFTs and all sorts of other things as well.
Yeah, and it's a relatively I know cryptocurrency has been around for a little while now, but in the scheme of things, it's still very much an evolving concept, and a lot of it, because it's a lot of it is online and there's servers throughout the world. It's really a multi-jurisdictional issue as well, is that it might be whether or not the particular jurisdiction and where those servers are located and where those cryptos may effectively be held actually recognise the authority of the person who's authorised within our jurisdiction to deal with those assets as well. So there's just so many different levels at play in terms of cryptocurrency and digital assets as a whole. And I know that we've covered off a lot of different things. So we've spoken about the different types of gifts that you might have in a will, and also the importance of really clearly identifying any specific gifts that are wanted in a will, as well as probably some of the issues that can arise if things aren't clearly identified or consideration isn't given to the estate plan in a more robust way and what a person's actually wanting to achieve. Probably just some of the key takeaways that I would say should be, well, hopefully gleaned from this is just making sure that a person has in mind effectively what they're wanting to achieve and really clearly articulating that as a part of their estate plan, and then working more holistically with the estate planner to make sure that those wishes can be carried into effect, and also have an understanding of what the implications may be if things aren't, I suppose, clearly identified or not addressed in the estate plan, and some of those complexities that can arise later on in the administration of the estate, and really work towards minimising those. And as we've touched on, it often can involve multiple parties, so not even just the estate planner. It might involve having a bit of a robust discussion with a person's accountant if there's some specific assets that are wanting to be given away, looking at potential tax implications. So it's quite a holistic approach in estate planning that needs to be taken into account.
That's why you got to look at those specific gifts and residuals as well. All right. Thank you very much, Emma.
Pleasure.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.